Hello friends, in this video I am going to discuss the Special Marriage Act 1954. India is country of unity in diversity as different religions and cultures are practiced. Marriage is a socio-cultural practice. Therefore, it is largely guided by the personal and religious law. Because of this reason, marriages in Hindus are regulated by Hindu Marriage Act 1955. Marriages in Muslims are regulated by Muslim law and marriages in Christians are regulated by Indian Christian Marriage Act. Now the question is, if it is interreligious marriage, I mean boy is Hindu and girl is Christian or vice versa, then which law will be applicable? The answer is such interreligious marriages can be registered under the Special Marriage Act 1954. However, before discussing the provisions of this act, let's understand first what is special about a Special Marriage Act 1954. The Special Marriage Act is enacted in 1954 to protect and validate the interreligious marriage. Under this act, a couple can register their marriage without relinquishing their respective religion. It means neither husband nor wife needs to relinquish his or her religion. Now, the question is, what are the conditions under the Special Marriage Act 1954? For the marriage registration, following are the important conditions under this act. Neither party has a spouse living. Neither party is incapable of giving a valid consent to it in consequence of unsoundness of mind, or though capable of giving a valid consent, has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and the procreation of children, or has been subject to recurrent attacks of insanity or epilepsy. Next, the male has completed the age of 21 years and the female the age of 18 years, and the parties are not within the degrees of prohibited relationship. Now the most important question, that is, what would be effect of the marriage registered under this act? As defined in section 19, chapter 4 of this act, effect of marriage on member of undivided family. The marriage solemnized under this act of any member of an undivided family who professes the Hindu, Buddhist, Sikh or Jaina religion shall be deemed to effect is severance from such family. It means the couple wouldn't get the advantage or privilege that an undivided family receives or have by virtue of being an undivided family. Further, rights and disabilities not affected by act. As we have discussed in previous slide, that the couple would be separated from undivided family and won't get any privilege or advantages that an undivided family usually has. But subject to the provisions of section 19, any person whose marriage is solemnized under this act shall have the same rights and shall be subject to the same disabilities in regard to the right of succession to any property. So, their property right won't be get affected because of such marriage. That will remain as it is. So this is all about the Special Marriage Act 1954.